Police Department is on the stand. I think we completed his direct examination, but we'll pick up this cross. So you may recall the jury.
Please rise for the jury.
They are present again this morning, so Officer Sletty, I would advise you also that you have the right not to be photographed or recorded while testifying. So what is your preference?
I have no objection.
You consent to be photographed?
Yes, sure.
Okay.
Yesterday, we completed the direct questioning of Detective Sletty.
The direct examination was completed, so the defense may cross-examine.
Thank you, Your Honor. Good morning, Lieutenant.
Good morning.
We've had a chance to meet and chat a little bit in this case, and now it's formal.
Yes, sir.
And those, tell me if I'm recalling correct, that is reflecting communication by text between Ramad Hall, go by Monty, and Elliot Dodell, go by Pac-Man.
The legend on the last page shows Kimberly Anderson connectivity, Edward Smith, Ramad Hall, and Antonio McCarlin.
7 people.
That's correct.
And flip if you would. In fact, if I can approach, I'll show you the page. The top legend first. That's Detective Phelps' work with Elliot Dodell's phone. Correct.
Correct.
In text to Pac-Man, at that price, I expect it to be delivered.
That's correct.
So Monty, ultimately, after diggering over the price, says, look, I'm gonna pay that much, you're coming to my house, right?
And that's what it appears in the text.
And you're a seasoned detective, you've talked about your background, correct?
Correct.
You talked to Mr. Irochi about your familiarity with pricing, both today and in 2013 for heroin, cocaine, right?
Correct.
A lot of your work, a lot of law enforcement these days, a lot of criminal justice time is engaged and involved in drug-related offenses, is it not?
Unfortunately, you're correct.
And am I also correct that in this day and age, including back in 2013, it is far more common than not that drug dealers have this weight? Let me interrupt my own question. This is not small weight. It was Monty's drug mart going on that night, wasn't it?
Correct.
Not the first time in your experience with Ramad Hall that's part of his underworld activity in your city?
No, that would be correct.
You've been to his house before?
Yes, I have.
When you're dealing with this kind of drug weight beyond the level of personal use, in your experience, would it be fair to say it's more common than not that people dealing this kind of weight are often carrying guns?
I did not view the crime scene in person, other than viewing the photographs that were taken.
By the time you arrived on deck, on shift, the crime scene was clear. Is that fair?
Mm-hmm. Yes.
And by that term of art, that would mean that it was released back to whomever. It was no longer in custody and control of law enforcement.
That's correct.
All right. Well, let me skip a beat and move to a few questions about Trayvon Booman. All right.
Sure.
I want to show you what's been marked for purpose identification as defense A and B. You had a chance to look at those right quick before we started your discussion.
Yes, I did.
Please tell the juror what those two documents are.
They are official court indictments for Trayvon R. Bobo.
And there are 2 indictments.
That is correct.
How many counts all told between the 2?
It appears to be 14.
And they range, do they not, from felonies of the first degree down to lower end felony 4s and 5s?
That is correct.
And based on your familiarity with law enforcement and the duties you hold, do you know what the maximum potential punishment is for felony 1 drug trafficking offense?
No, I don't.
Would you agree with me that that full set of charges carries a walloping potential maximum sentence, as in a long one?
If they're run consecutive, yes.
You had, in your familiarity with this entire investigation, you know, do you not, that Bobo was contacted within probably 10, 12 hours of these 2 deaths?
contacted,
Do you know when? Do you know that law enforcement had contact with Trayvon Bogo relatively shortly after these two deaths?
I believe so.
And that he did not provide any meaningful information?
That's correct.
Then you personally had contact with him on October 22nd, is that right?
Are you referring to the
Yeah.
transcript?
Yeah,
If I could?
yes.
What was the date again,
Well,
sir?
let me clarify. I think the face sheet on those says October 30.
That's correct.
So let's do it this way. Am I correct, you had two contacts with Trayvon Bogo after he was arrested on this set of drug charges?
That is correct.
And the first contact was you and FBI agent McBride and Detective Lemon.
That's correct.
He says at the beginning, I have some sort of rapport with you, and I'm here with these two other law enforcement, and we want to talk to you, right?
Yes, sir.
Now, by that time, Trayvon's looking at that load of potential charges, correct?
That's correct.
And when you and Agent McBride talked to him, you talked to him about a variety of topics, including these two homicides at Hiawatha at Molly's house, right?
Yes, sir.
And during that interaction with you, he made it clear that he wanted a deal for his information.
Could I refresh?
Yeah. You look back at, say, for example, on the first shorter transcript around pages 36, 37. And he's asked, are you willing to testify? And he goes, yeah, well, if I get something back. He wanted, in the lingo, he was willing to squeal for a deal.
What, I think he was asking for leniency.
Yeah, exactly. All right. So he was providing information, so the currency of information is paid in the trade of liberty. He wanted to lighten his penalty in trade for that information.
That's what he said.
Right. And he said the same thing in the next time you encountered Trayvon Bogo in the county jail after he'd been indicted. That was the proffer meeting, was it not?
Yes, sir.
The law enforcement, for the precise purpose of trying to lighten the penalty for their own charges in trade for information on something else, or even the case never done. Right.
Not exactly.
How would you define it?
What I would define it as when somebody has, as in this case, where they have some serious charges and they'll contact local law enforcement and potentially they may have some information or knowledge about a case or many times many cases because these people are out on the street and they're dealing with other individuals who sell narcotics, and they have sometimes some very good information. We'll bring in law enforcement, a representative, but normally the county prosecutor, in this case Mr. Irochi, and his attorney, the defendant's attorney. And basically there's a letter that is drawn up by the prosecuting attorney that basically spells out the rules, if you will, of the meeting. And then we will sit down. It's signed by both attorneys in the case, Bobo's attorney, he signs it, Mr. Irochi signs it, and then a witness, which in this case was myself, witnessing the signatures. And what will happen is nothing is offered or promised to the individual. That's what the purpose of the proffer is to see what the individual, what knowledge they have, and how it fits into the case or cases that we'll be working on.
You don't know if it's relevant, and you don't know if it's the truth to you.
Well, when we're in the proffer, a lot of times we know the answers to the questions before we ask them.
Right.
That's not uncommon.
So in this case, you use the pronoun he, you meant Trayvon Bogo signed that letter, as did his lawyer.
That's correct.
And Mr. Irochi was there, you were there, and Agent McBride was there,
Yes,
and the Attorney General was there.
that's correct.
The Assistant Attorney General out of Columbus was up here in that meeting.
He was present. His involvement was not in the current case that we're on today, but
A different one.
totally different case.
So Trayvon was at a proffer meeting with his lawyer because he was seeking a deal. He was trying to negotiate a deal, right?
He was providing us with information, and nothing was promised, even in the proffer letter.
Sure.
There was no deal, if you will, for a reduction or anything like that.
Well, there's no promises, there's no deal sealed, but that's of course what he was hoping for. That's what he was saying.
Objection.
Correct.
But anybody who's looking at, a large amount of charges, typically they will then volunteer the knowledge that they have that previously they wouldn't be so willing to do for in law enforcement. I recognize the photographs.
Okay, those photos, which were discussed and described, I believe, by Detective Dibble, are photos he took of the inside of Monty's house,
That's correct.
specifically the kitchen area.
It appears in this, yes.
And you've heard the testimony of course, him, and you've heard the testimony of Lavetta Williams, correct?
Yes.
And in this case, there was one projectile pulled off or from behind the cabin. Remember that testimony? You know that's in this case, right?
That's correct.
You heard the ballistics talk about it?
Yes.
You heard the testimony of Miss Williams regards the sequence of shots. There was one pause, 1, 2, 3, right?
I do recall her saying there were multiple
Or
shots.
recall specifically that you heard one and she reacted to it. There was some sort of pause before there were other shots that then everyone in the living room reacted to.
Objection.
Sustain the objection.
To your knowledge, were the two vehicles in that driveway, Ford pickup truck and some other black SUV or dark colored vehicle of some sort?
I wasn't there.
Were they searched?
I have no knowledge of that.
How close is the hospital to Lottie's house at the time?
It hasn't moved, less than a mile.
Oh, I'd say that Maudie's house, Maudie doesn't live there, Maudie lives in President now.
Correct.
At the time, was the hospital close to that address on Hiawatha?
Yes, sir.
And at the time, was the local emergency service, EMS, emergency medical service, was that also near that house?
They're located right next to the hospital.
You're aware, no doubt, that Mr. Smith was located and arrested around 7:15 in the a.m. on November 26th, is that right?
Yes, sir, I was present.
And you testified here a moment ago in some of my initial questions that there was drug dealing going on in Maudie's kitchen that night.
That's correct.
Is it your understanding that some of those drugs found in the hotel room had come from that kitchen?
I have no knowledge of that.
Lieutenant, you're a trained detective. You talked about, is that fair? You're in the business.
Yes, sir.
You know something about forensic tests, at least enough to know which ones to request and which ones not to request, right?
Yes, sir.
When you come on a particular kind of crime, whatever it might be, you have in your head and in your knowledge and in your experience what sort of forensic test might help you resolve one particular situation as opposed to any other particular situation. Is that fair?
Yes, sir.
So you're familiar enough at least to be responsible, hypothetically, for which tests you request on those submission sheets to BCI.
When we request items to be tested at BCI, especially in a homicide situation, excuse me, BCI will limit the number of items that they will test for DNA. If we submit 20 items and that's what we want, BCI will limit the number of DNA testing on particular objects.
Okay, well, that's interesting.
I don't know what that answer would be.
Of course you don't. Nobody asked him to do it, right? I have nothing further.
Can you redirect?
Just, and again, why didn't Ashtabula Police Department ask DCI to test the baggies containing the suspected drugs found in the hotel?
Because the defendant was in possession of them.
And that's sufficient for APD?
Yes.
Thank you. Oh, I'm sorry, Your Honor, I do have one question. Detective, I'm handing you what's been marked as State's Exhibit 187. Ask if you can identify that.
Yes, this is the proffer letter concerning Trayvon Bobo Jackson, and the date on it is October 30th of 2014.
And that's the proffer letter that you have testified about in cross-examination.
That is correct. My signature is on there as a witness, and it was dated 10/30 of 2014, signed by Trayvon R. Bobo and his attorney, Leo Talika.
There's evidence that the defendant was wearing a bulletproof vest at the time of the incident.
Where'd that evidence come from? As I recall, there's evidence they found the vest at the motel. But who testified he was wearing the vest at the Hiawatha Avenue address? I don't remember anybody saying
I believe
that.
that came in with Trayvon Bobo.
Bobo wasn't at the house that night. He
He
wasn't
had it that day. He was wearing it that day.
well that day,
Right.
but
But not at the house.
there's no evidence. I don't remember anybody testifying he had it at the house. An example is when somebody is poisoned. You know, you have to go buy the poison. You have to determine how you're going to administer the poison, and you have to know that this poison will take a life. That's a plan, scheme, or design. Okay, we're going to take a little break. I'm going to give this a little thought. I don't know if I may want to review a little bit of evidence here and see, but it's apparently the only issue is whether or not the state has offered enough evidence to send to the jury the aggravated murder charge of with the element planning and calculation and design. There's no request here not to send it on a murder basis, and that would be the next lower level would be a purposeful killing rather than a purposeful killing that was planned. So we're going to take a little break. I'll give this a little thought, and hopefully it's going to take too long to get this resolved. Okay. All right, with the record show, we're back in session on case number 14 CR 30, Ohio versus Edward A. Smith. The defendant is present with his two attorneys, and the two counsel for the state are also present. Everybody's here. Right, at the time we took the recess, the defense had filed a Rule 29 motion for acquittal. They were arguing that there had been insufficient evidence to reduce these charges that are pending from aggravated murder down to murder. Murder is a purposeful killing. Aggravated murder is a purposeful killing that's planned in advance, that there's a scheme or design. The court, I just wanted to take a few minutes to kind of review my thoughts on this a little bit and to review the definition. The definition of a prior calculation and design is as follows. It means that the purpose to cause the death was reached by a definite process of reasoning in advance of the homicide. To constitute prior calculation, there must have been sufficient time and opportunity for the planning of an act of homicide. And the circumstances surrounding the homicide must show a scheme designed to carry out the calculated decision to cause the death. No definite period of time must elapse, and no particular amount of consideration must be given. But acting on the spur of the moment or after momentary consideration of the purpose to cause the death is not sufficient. So that's the standard. Now, the court paid particular attention to what the prosecution argued was evidence as supporting this element of prior calculation and design as it applies to count 1 of the indictment, the count alleging the death of Elliot Dowdell. The reasons that were given by the state, the reason I was paying particular attention to what the state had to offer here is there's been a lot of evidence in this case. I was concerned that I didn't want to miss anything here. So here's the reasons that the state offered to the court. First of all, the defendant knew Dowdell. I know a lot of people. I'm not planning to kill any of them. And the fact I know them certainly isn't evidence that I'm planning, scheming, and designing to kill them. So the fact they knew each other does not show prior calculation and design. Dowdell sold bad dope. It's true, there's evidence in here he did, and there's evidence that the defendant was angry and wanted to make it right. There's no indication here that there was a killing being planned over this bad dope. There's no evidence that anybody made any statements that the Pac-Man doesn't make it right, I'm going to do this, that, or something else. It's just the evidence as I recall it, and as the prosecutor argued it, was that Mr. Smith was mad or angry. Next reason was the defendant knew Dowdell to be in Ashtabula on November 25th. Apparently he did know it, but that meeting wasn't arranged by Mr. Smith. It was arranged by Monty Hall. And I think all the text messages back and forth were between Hall and Pac-Man negotiating the price. Hall thought the price was kind of high, and I guess he said, well, if I'm going to pay that much for it, you're going to have to deliver it. But again, that wasn't arranged by Mr. Smith. It was arranged by Hall. The defendant obtained a gun before the murder. There's evidence in this case that just about everybody involved in this case has had or at least handled a gun at some time. We've got gun residue positive evidence on both of the deceased, Mr. Ramey and Mr. Dowdell. There was evidence that it was on one of Monty Hall's hands, and there's evidence it was on both of Mr. Smith's hands. So the fact these people own guns, it looks like everybody in this whole case owns a gun, or at least has handled them. But again, obtaining a gun before a murder takes place, it doesn't prove, it's not evidence that would support a jury finding because he bought a gun or had a gun that day, that he was going to use it to kill any specific person. And I don't recall any testimony, and the prosecutor hasn't offered any, that any of the people that were around Mr. Smith that day heard anything out of his mouth that might have indicated what he intended to do. So the last fact was there was a bulletproof vest that was found at the hotel. No evidence anybody saw him wearing it at Hall's house the night of the shooting, the killings. And the fact that you own a bulletproof vest, you can't extrapolate on that and say, well, because he owned the vest, he was going to plan to kill somebody. So I've looked very carefully at the reasons offered by the state, and I find that they have not offered sufficient evidence which, if believed by the jury, would support a finding of prior calculation and design. The court should deny a Rule 29 motion if the evidence is such that reasonable minds can reach different conclusions as to whether each material element of a crime has been proven beyond a reasonable doubt. And I'm going to make a finding that there's insufficient evidence in this case to reach any conclusions that would support a finding of prior calculation and design. The state has already admitted there is insufficient evidence to show prior calculation and design on count 2. That was the count with Mr. Ramey. So the court is going to grant the defendant's Rule 29 motion, and I am going to dismiss from this case the element of prior calculation and design in count 1. That's over the objection of the state, and I'm going to also dismiss it in count 2 with the acquiescence of the state. That's the Ramey case in count 2. So from this point on, the charges in this case are murder, not aggravated murder. I think I'll have to explain that to the jury when they come back in, because when they ultimately get the instructions in this case, won't be any mention of aggravated murder. And Okay,